welcome to our first series of questions and answers with our Greyford solicitors. Today we'll be discussing what will happen and how COVID-19 might affect your divorce settlement. We'll be speaking with Neil Graham today, who's one of our partners at Greyford's, and we're going to be asking him some questions. So we're going to kick off with quite a common question, which is, are the courts still currently dealing with financial settlements?
Hello, Sarah, thank you. The short answer to that question is yes, they are still dealing with financial settlements. Usually financial settlements will fall into two categories: either those that are made by consent, by agreement between the parties, or those that are imposed by a judge after a final hearing. And the ones that are being lodged by consent, so financial settlements where people have agreed between them how the capital and the income resources are to be dealt with, are still being lodged on paper, as they always have done in the past, and the same usual process is still applying to those. There is perhaps a slightly longer delay at present because the court staff have a lot to be dealing with, but those settlements that are lodged by consent are still carrying on in the usual way. So there's been no change to that process.
Okay.
Settlements that have been imposed after a hearing, of course, are different because the process we're going to come on and find out about for hearings at the moment has changed. So if you have a final hearing coming up at which a judge is going to impose a settlement by way of a judgment, then that will still be happening, but there are some changes to the way in which those hearings are going to be taking place, which we'll come on and discover in a minute. So in brief, to answer your question, yes, the courts are still very much dealing with financial settlements.
Okay, great, thank you. That's very helpful to know. Our second question is, if I have an upcoming financial hearing, what will happen next and what can I expect?
That's a very good question. And actually that leads rather nicely on from your first question. And the answer to that is hearings are also still going ahead. The key to that is the information that was released by the President of the Family Division, Andrew McFarlane, last month. And the general effect of that guidance from the President of the Family Division is that the court system is very much still working and that it's in the public interest for that to continue to happen, but that the risk of spreading the virus and exposing people to it should be minimised. So that's the general guidance. How that filters down to local courts slightly varies depending upon the resources of that court and depending upon the procedures that they put in place. But hearings are still taking place. They're either taking place on paper, which is where everything is submitted in advance, and a judge then goes through the paperwork and decides what order to make, and that is sent out to the parties. Or if it's not possible for that hearing to take place on paper, then the hearing will take place remotely. And that usually means either via telephone or via Business Skype or BT Meet Me. Now, this is where it gets slightly more complicated because although the general guidance from the Family Division is to keep the court system very much working, the local way in which the courts deal with that can vary. The Central Family Court, for example, has requested that all paper hearings are done by way of the accelerated process. You try to agree between you the order you want the court to make. Some courts are automatically vacating all the hearings and relisting them. So the answer is, what will happen next is the hearing will still go ahead. What you can expect as to exactly how it goes ahead will depend upon your local court. Okay. What all courts are doing are sending out orders to the parties confirming the arrangements that will apply. But because the poor court service is very overburdened at the moment with even more work than usual, it would be wise to try to make contact with your local court via email to find out what the general practice is in that local court in advance of getting the order, so that you can prepare appropriately for the hearing, whether that takes place on paper or remotely.
Okay, thank you, that's great. Our third question is, if someone's assets and income have changed due to the economic impact of COVID-19, what should they do with regard to their financial disclosure and the possible negotiations?
That's a very, very good question. The basic principle that underlies the way in which the courts deal with financial claims in England and Wales is that the courts have to understand what the capital and income resources are in order to decide what orders to make in accordance with the relevant statutory legislation. So the court has quite wide powers to redistribute assets in accordance with what we call the Section 25 criteria, which is the bit of legislation that tells the courts how they have to deal with claims. So key principle to working out how to deal with the assets is actually identifying what the assets are and what value is attributable to them. The courts have quite wide powers to deal with that and make orders for valuations to be obtained, etc. And the parties have a high duty of financial disclosure themselves in Form E and any other disclosure that's required as part of that process. So there is a high burden of a duty and a burden to discharge on the parties to be honest and full and frank about their financial disclosure. Now that burden continues until the proceedings have come to an end. So the duty to provide financial disclosure is ongoing. So it doesn't just apply when you complete your Form E and you do your financial disclosure early on in the proceedings. It continues until the moment those proceedings are concluded by an order of the court. And it also applies to parties who are lodging agreements by consent, which we talked about earlier on. There is still a form that has to be completed called a Form D81, where you're lodging a consent order to summarise the parties' resources. Now, that duty continues. So if there has been a change in a party's capital resources or income position, then there is an ongoing duty to disclose that, both to the other side and to the court.
Okay, thank you. That's really helpful. The next question is, I've been furloughed or I've been laid off. How could I deal with maintenance, whether that be paying or receiving?
So that leads us on nicely from your last question, because if there isn't an order at the moment, so if you have not reached an agreement, or if the court has not made an order after a hearing to decide what maintenance should be payable, then there is obviously not only a duty, but also a need to disclose your changed income circumstances if you are a person who would be receiving maintenance, or if you're the person who would be paying it. If there's an order that's already made, then the general position in relation to income, so maintenance, is that that order continues in place. But whilst maintenance is payable, it is possible to ask the court to vary that, to review the level of the maintenance that is payable. And in order to do that, generally, you have to show to the court that there has been a permanent and fundamental change, not just a bad month or a bad year, but that something has happened to make either the capacity of the payer to pay fundamentally and permanently changed, which might lead to an application for a variation of that maintenance order, or for the income of the recipient that has changed, which might mean that their needs have increased because they are no longer able to supplement whatever maintenance they receive with their own income. Now, it's quite a complex and specialist area, and there's quite a lot of case law about variation applications. And so the first thing you should really do is make sure that you've got the financial information available to go and consult a solicitor about whether the circumstances give rise to the need to make an application to vary, either if you're the payer or if you're the recipient of maintenance as a result of changed circumstances as a result of COVID-19. Because making an application to the court has quite significant cost consequences, it's important not to make that application unless you really are comfortable that there's some success or prospect of the courts changing or varying the maintenance order. And that's why it's very important to get good advice at the beginning before you commence that process. Okay,
thank you very much. The next question is, I have an existing financial order in place, or perhaps a maintenance order in place. My financial situation has changed because of COVID-19. Can that order be set aside or altered, and what options are available to me?
So that again leads us very nicely on from the question you just asked, and we've addressed in the last question the income position. The capital position is different, and generally the position is that capital orders cannot be undone. So once an order has been made either by consent, or an order has been made by a judge imposing an order after judgment after a hearing, the capital elements are not reviewable. And there's a reason for that. And the reason is that it's generally in the public interest for there to be finality to litigation. Generally, people have got better things to do with their lives than litigate, unless they absolutely have to. And therefore, there is a general overriding principle that reopening capital settlement is not something that should happen, because it would undermine that principle, which is seen to be in the public interest. There are limited circumstances in which that can still be done. There's a body of case law surrounding whether an application can be made if there is an unforeseen supervening event which would have had a material effect upon the order made by the court if that event had happened before the order was made. Those applications are very difficult and complex. And again, they should not be made without expert legal advice first, because the chances of those applications succeeding can be very remote, and the costs of commencing that process can be quite significant. So again, the answer is really rather like the answer to your last question. It's possible, it is conceivable that it might be possible to review the capital element of an order, but it should not be done lightly and only after expert, detailed legal advice.
Thank you very much. The next question on the list follows on slightly from the previous question. This person asks, I am meant to be selling a property as part of my financial settlement. As a result of COVID-19, this is currently difficult or not possible. What should I do?
That's a question I think probably a lot of people are asking. And in many respects, it's more a practical concern than a legal concern, because selling a property is often, in matrimonial cases and financial cases, the key to unlocking a settlement. And it's very usual in family cases for the matrimonial home to be one of, if not the biggest principal asset in a case. And the court has powers to order that property to be sold and the net proceeds of sale to be divided between the parties by way of payment of lump sums to the parties in whatever manner the court thinks is appropriate after applying the statutory criteria. So for many people, getting that lump sum to buy their next property will be inextricably bound up with selling the family home. And the court has powers to order that property to be sold, and in extreme cases where one party frustrates the sale of the property, for example by refusing to sign the transfer documents, the court itself can step in and perfect those documents. The question you asked is a different one though, which is where people are willing and want to get on with the sale, what can they do if they can't complete the sale? And the current guidance from the government is that completions of sales of properties should generally not be taking place. So I think the answer is that the practical concerns are probably going to be more important than the legal concerns. If somebody's worried that a party might rush off to court and make an application for the court to step in and perfect the sale of the property, the completion of the property, I think that's unlikely, because it would be unlikely that orders would be made that would contravene the current government guidance. So I think it's really a matter of being able to market the property and sell it in accordance with an order just as soon as the restrictions are relaxed and the government advice allows that to happen.
Okay, thank you very much. The next question is, I am asking for pension sharing order. How might COVID-19 affect this?
That's a good question and a slightly more complex question, because again, that's not so much a legal consideration. Since the law was changed about 20 years ago, the courts have had the powers to award part of a pension to a party. Historically, the courts didn't have the powers to do that. All they could do was give an offsetting capital lump sum, because pensions couldn't be split. Pensions can now be split, and the court can make what's called a pension sharing order. And in effect, what that does is it hives off part of one party's pension and gives it to the other party. That can either be done by way of the party keeping that separate share within the scheme or transferring it to a scheme of their choice. But the court has the power to do that, and typically that is done by way of a pension sharing annex attached to the order expressing the percentage of the pension that goes to the receiving party. And the rationale behind that is that if a pension has been built up throughout a marriage, it's a matrimonial asset, and therefore it should be capable of being shared in accordance with that pension sharing order. Making those orders will not be affected by COVID-19, but implementing it may be a little bit more difficult. That's because people are still isolating, people are working from home, some people are ill, and therefore, just like any business, people who are dealing with pension sharing orders may experience difficulties in being able to implement them. The statutory requirement is that the trustees of the pension scheme have up to 4 months to implement it after they've received a copy of the order, the decree absolute, and the relevant information contained in the pension sharing annex. Now, this is the difficult part, because the trustees have discretion as to when they implement that pension sharing order within that 4-month period. And so it's impossible to control the exact date upon which that pension sharing order will take effect and the transfer will take effect in favour of the receiving party. Now, ordinarily that's not a concern, but in the current market and current climate where markets are volatile, it can make a big difference. We've already seen only yesterday that American oil producers are actually having to pay people to take oil away. And that's in a sector where oil prices have always usually been quite high. And so if people are thinking about investing that pension credit, the part of the pension that they're getting by way of pension sharing order, when you invest it and in what vehicle you invest it is going to be quite crucial. But there is no way, as I say, of controlling exactly when that pension sharing order takes effect within the 4 months. But it would be sensible to take advice from an independent financial advisor, not only because they'll be able to give you advice about what units and what schemes to invest your pension credit in, but they may also be able to liaise with the trustees of the pension provider to make sure that it takes place at a time that might be advantageous to the person receiving it.
Okay, thank you very much. Our final question really is, if someone would like further advice or advice bespoke and tailored to them during this time, how can they get in touch with Greyford's and what can we offer them?
So I'm glad you asked me that question, because obviously we are very expert here at Greyford's in offering advice in all areas of family law, and in particular in relation to the financial consequences of breakdown of relationships. The Legal 500, which is the leading directory for the legal services industry, recognises that, and we're included in that as a firm that has the expertise to give detailed and specialist advice on this area. We've got years of experience here at Greyford's of doing that. And obviously we're very happy to help anybody who wants assistance on that. Like all law firms, we have to give you a client care letter that sets out how we charge and how we work and our terms and conditions before we do any work, and to give you a rough idea of the costs of each stage. Before we do that, however, we're here to help in ways that we can. We offer complimentary consultations, either by telephone, by Skype, or by other remote means. We also can be contacted on the website if you have an inquiry and you want to set up one of those consultations. We also have a live chat facility on the website. It's not always easy to talk on the telephone if you're in isolation and locked down, but that also enables you to make contact with us. And we're here and happy to help in any way we can by any of those media.
Oh, great, that's wonderful. I think that covers all of our questions today. So thank you very much for your time, Neil. And hopefully this interview has been helpful for people looking for some advice during this difficult time. Thank you very much.
Thank you very much, Sarah. Bye-bye.
Thank you. Bye-bye.